not those of Vic Canellis Media Group, its parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Good evening, South Florida. Welcome to another Ask the Experts. Our show, I'm proud to say, has been running over 7 years now. And our show tonight, it's the first show of each month that we have been running now for over 4 years. I can't believe how many people sit down, take the time to write us, to text us. I think we broke a record this past month of how many texts that we got from our listeners, and great questions. So if you have a question tonight, you can still get it in. You can text at 954-336-3767, but you can also call in live to the show. We take live callers. You can call here at 888-565-1470. Let me welcome you, my friend, our great guest, our great expert, since he's a board-certified attorney, Robert Kaye of Kaye Bender Rembaum. Good evening, Robert.
Good evening, Steve.
Where are you at tonight? I'm not used to seeing that background.
Well, I'm in my office. Usually they zoom in more on me.
Oh, okay. Well, it's good to see you, and people are loving the new show, the last Thursday of each month. And we had...
Lisa was a good guest for you.
Yeah, we had Lisa McGill on, who I have been hearing about for years, and I finally got to meet her. So
yeah, Lisa was a good guest for you.
Oh, it's a great guest. Anyway, Robert, some of the emails I get are people who were just listening to the radio, sitting in the car driving home from work, and they were playing with the dial and found our show by accident. We don't care how they find it, but a lot of people have found our show by accident. A lot of people love the show. So for those new people, tell people about Kaye Bender Rembaum.
Well, Kaye Bender Rembaum is a full-service law firm specializing in the area of community association law, being condominiums, homeowner associations, cooperatives primarily, dealing with issues of statutory interpretation, document interpretation, enforcement of documentary restrictions, advising the board as to their rights and obligations under the governing documents, negotiating contracts, addressing contract disputes with third-party vendors, dealing with construction defects, developer claims, collecting unpaid assessments. Pretty much anything that a community association will be dealing with on a day-to-day basis from a legal perspective are the services that we provide. Been doing so continuously for 30 years.
It's like running a large corporation, isn't it?
Well, some are larger than others, but yes, it's definitely running a corporation, also like a mini city.
Well, what we do on the show is we actually take callers. You can call in now if you live in a HOA or a condo association, or if you're a board member, you can call us here at 888-565-1470. And also, we must have 30 questions tonight that people wrote in wanting answers to, and we try to get to as many as we can. And we're going to start off with one of our texts that we got from Sean in Coral Springs, Robert. He says, does the board in a condo have to vote to pool reserves annually, or is it a one-time deal, and then you are stuck with pooled reserves?
Well, first off, pooled reserves is a feature that allows a condominium association to take their various categories of reserves, the roof, painting, paving, anything that's got deferred maintenance over $10,000 in a year, and put them into a single pooled account for accounting purposes while still maintaining specific balances. It can be complicated. It does need the assistance of an accountant quite typically, but it does require a vote of the membership if you're changing from a pool or from a straight line reserve where everything is categorized individually to a pooled reserve where you're putting it all together. Once you have the vote of the membership to pool it, it's up to the board each year if they want to continue pooling. If the board decides they want to go back to the straight line method of categorizing their reserve accounts, the board can change that itself on an annual basis. But if it decides it wants to go back to pooling, then again will require a vote of the owners. If the board decides to keep pooling, it'll continue to be pooled until the board changes its mind.
Okay. We've had so many great questions. I just want to say real quickly, a friend of the radio biz, talk radio, passed away today, Rich Stevens. Really sad. Yeah, he had a heart attack. Wasn't sick, but we just want to give our condolences to the family. I didn't want to forget that. Let's go to Julie in Delray. Says, Robert, I love your show. I've been a fan for the last 2 years. I'm in a condo, and for those of you who write, it'd be really good if you let us know if you're in a condo or an HOA, because there are different statutes and guidelines. If there is a designated amount in a monthly budget to go to the reserves, for example, $30,000, and the board uses $20,000 of it, special projects, is this legal?
Well, reserve funds, money that are specifically earmarked for reserves in condominium, can only be used for the purpose that they are being reserved for, unless a vote of a majority of the owners present at a meeting in which a quorum has been attained decides to reallocate those funds for something else. So based on the question, I would assume that there has been no vote of the owners to use the funds for a different purpose. Under that set of facts, it sounds like the board is not acting properly in using those reserve funds on other projects.
If you'd like to give us a call here and you have a question for attorney Robert Kaye of Kaye Bender Rembaum, you can call us at 888-565-1470. Stefan in Palm Beach wanted to know, have the new condo laws been published?
Well, yes, of course, the laws are published in that they are in Florida statutes, which are available online. You can also do a Google search if you want to see the specific changes that were made this summer or this spring in the special session as it relates to the condominium reserves and the studies. Just Google SB 4D. S is in Sam, B is in boy, Senate Bill 4-D as in dog, and it'll come right up and you'll have the text of that particular Senate bill with all the changes that were made on that particular issue.
Are there a lot of changes?
Statutes. Yeah, there was a lot of changes just in that particular bill. while it was lengthy in the page number that it prints out to, a lot of it is existing language and with changes interspersed throughout it. But there were significant changes made, creating the obligation to do certain milestone inspections of buildings and reserve studies, and taking away the ability to waive reserves on anything that's structurally related, certain requirements for three-story condominiums, other requirements for all condominiums. There's also different guidelines for timing relative to the location, how close it is to the ocean or the Gulf of Mexico, versus those that are more inland will have some slight differences in the timeframes of the initial requirements of inspection and reporting.
Are you satisfied with the new laws?
Well, of course not. They were quickly adopted and passed. They do have technical issues. They do have a lot of questions that are still open. One open question in Broward and Miami-Dade County is everybody that's in these counties are required to have 40-year inspections, and then every 10 years thereafter, for those that have had those 40-year inspections or relatively recently had them, are they still required to do the same in-depth investigations of their buildings that is required in the statute? It's unclear. There are opinions on both sides of the issue that are out there. So the conservative one would be, yes, you still need to follow the statute, because there are additional things that are required that weren't required before. And so that's certainly part of the problem.
Robert, one of the questions we got from Jonathan in Pompano: if our condo has been certified for 40-year certification, will it still need to be inspected again?
Well, that's what we were just talking about.
Right. I mean, we got a question on that.
Oh, yeah. So many people ask that question. When I read the statute, that question popped into my head right away. And obviously, being as new as it is, nobody really knows the answer to that. So it's the prudent advice. And since the inspections aren't due until the beginning of 2024, we anticipate that the next legislative session will clarify a good number of these questions that have been raised on the new legislation. I'm aware of different groups out there that are proposing different changes and corrections and tweaks to help make it more streamlined and understandable. One of the biggest concerns is the fact that all these condominiums are required to have reports by licensed engineers or architects, and there aren't enough of them in the state of Florida to do all of them within the time frame that is indicated under the law. So there's going to have to be some kind of consideration given to that particular problem, and I'm not sure how they're going to resolve it at this point, but it's a pretty obvious one.
Yeah, that was one of the questions I had for Lisa last week, was where are they going to get all these engineers and architects for the whole state?
That is a big problem.
I can't wait to see how they're going to work this out. Hey, we're going to go to break. Rob, when we come back, you've got a schedule that we're going to go over. Give everybody your phone number and the website address.
Well, anyone who wants to reach us can call 800-974-0680. That will get them through any of our offices in Pompano Beach, Palm Beach Gardens, and Tampa. Or you can go to our website, kbrlegal.com. There's a contact box on the first page of our website that they can fill out that will have somebody get back to them. Or you can send an email to info@kbrlegal.com, and someone will get back to you in that respect.
You got to look at Jeff's morsels. Those are the best. Anyway,
No,
we're going
Jeff's are
to go ahead.
Rembaum's Roundup. Legal morsels are something else, but both
Okay.
of them are good.
Well, I enjoyed the morsel one. Anyway, we're going to go to break. We come back. We have more with attorney Robert Kaye. Kaye Bender Rembaum. We'll be right back.
Kaye Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kaye Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kaye Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kaye Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Expert show, and I know we have calls waiting. Let me just go because they've been waiting for a while. Well, our system just went down again. Don't go anywhere, callers. We will be right with you. You want to go over your schedule, Robert, of what's coming up this month?
Sure. We have a few interesting items on the calendar for the upcoming month. All of them are going to be via Zoom, so they will require you to RSVP or get yourself checked in so that you can get the credentials so that you can participate. The first is next week on August the 10th, Wednesday, from 11:30 a.m. to 12:45 p.m. is a lunch and learn Q&A. The topics include cyber stalking and defamation in community associations, among other things that the participants want to talk about. Will be hosted by us and featured Sean Brown from our Tampa office. On Thursday, August 11th, we're going to do a condominium association board member certification. That will be from 12 noon to 2 p.m. Andrew Black from Pompano Beach office will be the instructor in that. Then on August the 17th, also at noon from 12 to 1, hosted by the Castle Group, Community Association Q&A, Association Leadership, Episode 12. Panelists with Michael Bender and Jeffrey Rembaum from 12 to 1 on August 17th. And then on August the 25th, from noon to 1, there's a presentation by Andrew Black again, hosted by Campbell Property Management, guest restrictions and screening tenants and new owners. That one has continuing education credits, as does the board certification course for any managers who participate and get credit on that. For all of these courses, go to our website. You register at kbrlegal.com/event-calendar, or you can go to the website and click on the calendar, pick the item that you're interested in, and register that way.
Busy month.
Yes, it is. And it's summertime, no less.
Yes, I know. Hey, let's go to the phones. Let's start off with Maria in Broward. Good evening, Maria.
Good evening. Hi, please. I have a question for the attorney. So I live in a HOA, and the documents indicate that the membership in the association shall be limited to record owners of the lots. So my question is, can the owner give an authorization or a power to somebody else, let's say a spouse that is not on the record, to attend the meetings and actively ask questions or participate in the meetings? And the second question, can that person be part of the board just by having power or an authorization from the record owner?
And did you say you were in a co-op?
HOA, yeah, homeowner association.
Oh, a homeowners, okay. In an HOA, there is no oversight from a governmental agency like the Division of Condominiums for homeowners associations. The statute provides that meetings of the association are open to the membership, and it doesn't say or their representatives or holders of the power of attorney. There have been opinions given by the Division of Condominium that the powers of attorney should be allowed to attend meetings on behalf of the owner in condominiums unless the governing documents, the Declaration of Condominium, provide specific restrictions as to that. There is no similar holding in homeowners associations, so it's going to be up to the board whether they're going to allow a power of attorney to participate in meetings. Qualification for the board is specific to the governing documents. The statute provides in 617, the corporate statute, that unless the documents require it, anyone can serve on the board. You don't have to be a member. So you have to look at your articles of incorporation to see if membership is required as a qualification to serve on the board. If it doesn't say that, then anyone, including the holder of a power of attorney, can qualify to serve on the board. However, if it does require membership, then it can only be the member. It's not something you can delegate through a power of attorney. So you'll have to check your documents on that particular issue in order to know for sure.
Does that answer your
Did I
question,
cover
Maria?
everything?
Yes, thank you so much.
Thanks, Maria. We have a line
Thanks for
open at
listening.
888-565-1470. Let's go to Nicole in Fort Myers. Hi, Nicole. Thanks for waiting.
Hi, thank you for taking my call. I am a CAM and manage several HOAs. I am aware that the declarations or the governing documents are supposed to be provided to new homeowners when they buy a property within my association. However, I always get someone who says, I was never provided these documents. How can this be proven, whether they did or did not receive them?
Well, when you say that they received them, are you saying from the person they purchased from or from the association?
During their closing.
Okay, well, that's nothing that you can prove or not, because it's not something you're a party to. And they don't usually keep records of that. Sometimes they may be a receipt, but generally speaking, it's not the association's obligation to provide them either. The associations are required to maintain copies that they can give to people upon request when they pay for the copies that are made at whatever the reasonable price of creating the copy is. But they don't have, there's no entitlement in a unit owner to tell the board that they have to give them documents. They're available in the public record. Any owner should be able to get them by going to the public records.
Thank you.
If they don't get them from the association.
Thanks, Nicole, all the way from Fort Myers. Let's go to our next call, Kevin in Palm Beach. Hi, Kevin.
Hello there. Can you hear me?
Hello, Kevin.
Yes, we can hear you fine.
Okay. Okay, my question is about the governor's new bill, 2022-268. I own a townhouse, 4 units per building in an HOA community. Our board said the governor's new bill does not apply to our community because the bill is for single-family homes only. I reviewed the governor's bill and I don't see the language, single-family homes only. Is our board correct?
Are you talking about something pending or something that's already passed?
I believe the governor's bill was already passed. Yes, it's
Well, then
2022-268.
it's not the governor's bill anymore. It's a part of Florida laws.
Okay,
So
Florida law.
if you're referring to Senate Bill 2 that was adopted at the special session that deals with the insurance issues, that particular statute makes reference to residential roofs without identifying whether it applies to community associations or not, which creates a little bit of an ambiguity and a problem. So if a carrier decides that they're going to interpret that to not include an association or a condominium or HOA type property and refuses to provide insurance, that may be something that's actionable, but that's something that would take time and litigation to resolve. You can't necessarily force them by saying that's not what the statute says. Sometimes we've been successful through stern letters from our office to various insurance companies that had denied coverage for certain reasons to get them to change their mind, but that's not always the case. They hold the cards when it comes to those decisions. If it's a wrongful denial, there are avenues to approach, but they don't happen overnight, unfortunately.
Okay, so we have an ambiguous new law that.
Oh, that's not unusual at all.
Okay, great. Okay, I guess that answers it for me. But you don't see the wording "single-family homes only." That's what I'm trying to figure out. Where did our board come up with that? That it's for single-family homes only?
That might have been what the insurance company told them when they denied coverage. If the board's making that interpretation on their own, I don't know.
Okay, and we have a commercial policy for residential townhomes. Do you know, is that typical? A commercial insurance policy?
It's not atypical for insurance carriers to treat community association coverage as commercial type insurance rather than residential, even though there are residences involved. That's not an unusual part of the insurance industry.
Okay. All right. I appreciate your answer.
Thank you, Kevin.
Thank you for listening.
Let's go to Kathy in Deerfield. Good evening, Kathy.
Hey, can you hear me?
We can hear you fine.
Sorry. Okay, so my question is, it's in regarding to the sale of a unit in my building, and I want to know how much should my management company be doing regarding the application? That's one question. What kinds of questions are we allowed to ask? Like example, I'm looking at the application. They're self-employed, and many residences they've lived in a short period of time. Is that a red flag for us?
Well, what you're talking about isn't necessarily legal issues, as they are more business decisions that a board would need to make in establishing criteria for what it considers when it's reviewing prospective purchasers. But the limitations on what you can ask are generally the more constitutional type protections than they are anything else. You have an entitlement to know about their background in renting, their background in criminal, their background financially. you have an entitlement to ask all of those questions and get documentation to support it. And so, is there something specific that you're not sure about?
Well, what I'm considering is this: the person buying it is paying for the apartment, but they're only going to reside in the apartment unit for 2 months out of the year. Their brother is going to be an occupant full time, who is unemployed, has no financial background. So our concern is, does a person buying the apartment, are they the one required to live in the apartment? We're not a rental building. And what is an
Well,
occupant?
That's going to depend on your specific documents and what restrictions there may be. In instances like you've described, people often say, well, my brother is living there as my guest. He's not a tenant, so we're not renting the apartment. He's living there as part of my family. And some documents allow you to require a background check of all occupants, which makes sense, regardless of their financial involvement. The last thing you need is a convicted sexual predator living in your community that you didn't know about until after he was already there. So doing background checks of all occupants certainly makes sense. Whether you can use the information or not is also an evolving issue, because the federal government, through Housing and Urban Development, HUD, periodically issues guidelines relative to using criminal background as a basis to disapprove. And while it's allowed, it's becoming more and more limited in the types of criminal behavior that would qualify the requirement of convicted felonies, and relatively recent in time and of a nature that would pose a danger to the residents. So it's not a blanket. If they have a criminal background, that you have to deny them. In fact, it's better off to consult with the attorney to make sure that you're not crossing a line and getting yourself in potential trouble that way. But your governing documents are going to be the guidelines as to what you're able to ask for, what you're able to limit, and how you're able to control who's going to be occupying at any given time. If your documents don't provide what you believe they should, if they don't provide what you think they should, then you would want to consider perhaps proposing amendments to the membership, get a vote of the owners if possible, if you can get enough owners to support, to provide for the provisions in the documents that you need.
And that's what we're in the process of doing, but unfortunately this sale came up now and we don't have that yet. And our documents are not clear. I don't even know if a lawyer could understand our documents. So
well, we do the best we can.
I know. It's so difficult for a novice to understand it, and I don't know how far we can go with these background checks, because what's been done by our management company seems cursory at best. And they've advised us to contact our attorney with these questions that I've asked them. So I don't know.
Well, your attorney would be more familiar with your documents. Your attorney should be familiar enough with your documents to provide the assistance on the question that you're posing.
Okay, so maybe that's the area we have to go in, because I'm still not convinced that we're doing the right thing, or maybe we're making too much out of nothing.
Well, if your attorney is unable to help you, certainly give us a call. We'd be happy to provide assistance.
Okay, thank you.
Thanks.
Thanks for answering.
Let's go to Mike, all the way in Pennsylvania. Good evening, Mike.
Mike.
Good evening. You hear me okay?
We can hear you fine.
Good. Prospective buyer in a condo wrote that they had 3 indoor ESA cats with appropriate paperwork. However, the cats are not vaccinated. but the cats are going to be kept in the apartment the whole time. Can we require that the cats be vaccinated before we interview them?
You will need to have criteria written and available to any prospective purchaser or any actual resident requesting a reasonable accommodation for an emotional support animal that includes the requirement of the vaccination and documentation of it as part of the package prior to compelling that. So if the board has not created that as a criteria, you're going to want to do that first. It could apply to existing situations. I'm sorry?
I'm going to ask, is that Florida law, or is that something that has to be established afterwards? In other words, does it exist as a law at this point that we don't need to? Go ahead.
Florida law requires you to have these types of criteria in place. It isn't just Florida law, it's actual part of federal law and fair housing. Since the person that's making the request is falling under a physical handicap protected classification, and so that it's very skewed in favor of the requester and against the association and the requirements. So you need to be very specific in complying with all of the minutia details that the governmental agencies throw at the association on this issue. But the last thing you want to be is
Go ahead.
go ahead.
I cut you off. The question is,
That's okay.
If the cats are not vaccinated, but they're going to be staying in the apartment the entire time, can we object to interviewing these people because of that situation?
Only if you already have the limitation in place. If it's not already in place, then you don't have a basis to not interview them.
All right.
Not a legal
I
basis.
see what you're saying. Okay. Oh,
You want your ducks in a row first.
what? Okay. All right. Well, thank you.
Thanks, Mike. Let's go to Lisa in Boca Raton. Hi, Lisa.
Hello. Hi. Hi, Robert. Great evening.
Hello, Lisa.
And thanks for answering our questions. I've got a two-part question, if you don't mind.
It cost you more.
What's that?
It cost you more, Lisa.
Okay.
Go ahead.
So we're in a country club, multiple communities within the country club that are HOAs or whatever. There's a master POA, and they hold meetings. Usually when they hold a meeting, before they put out a sign up at the front gate to say that there's going to be a meeting, on a Tuesday, say whatever time. So recently they put up a notice at the front gate to say they're having a special meeting, and they did not say anything what the purpose or anything else was. So emailed them and said, based on our docs, it says the master bylaw says written notice should state the place, date, and hour of the meeting. And in the case of a special meeting, the purpose or purposes which the meeting is called shall be given to each member not less than 10 days, not more than 60 days before the date of the meeting. Okay? And further down, it also says in 5.07, notice of each meeting of the board shall be delivered to each director and each member. So as it was a special meeting, and we heard through the grapevine that they're going to be changing some of the bylaws or something. So each community has one representative that goes and votes. So they would not send out what the purpose of the meeting was, and the email response was simply that, a 14-day notice was given. Notice has been posted Letters sent to board of directors were mailed, and the representative had plenty of notice. So couldn't find out what it was, and wasn't able to attend because it was at 10:30 in the morning. So in that case, when it's POA, are they, what's your interpretation there, do you think?
Well, unfortunately, the documents tell the tale that I need to see more so than as you've described. I understand the concept, I understand the hierarchy. Do you have contact with board members within your own particular neighborhood or HOA?
Yes, I'll have to get to him and find out. Yeah. So we have
That's the one where you'll get the details. In some instances, communities such as what you've described for you are representative as opposed to individual ownership driven. So you have representative for your neighborhood and representative from the other neighborhoods that are considered the quote unquote members that get notice and entitlement to participate at meetings. And typically that's the board of directors or the president of the individual neighborhoods. If your documents are written that way, and it sounds like that's the way they're proceeding and the way they've done this, that wouldn't necessarily be wrong. It's just the responsibility of your own individual representative to keep the owners within the community informed of what's going on. So that's one possibility. It's possible they're doing it completely wrong, but without reviewing the documents, I couldn't say 100%.
Yeah, because in the declaration part, they have to have 2/3 of the members approve a change, but the bylaws is different. So they have a little more leeway there. But again,
when you've got representative participation, like the president of your community could be voting for all the owners there, and the number of owners in your neighborhood and the number of the other neighborhoods up to a majority could control when there's only maybe 5 or 10 people participating.
Right. Okay. All right, we'll leave it alone.
So I would start with your president and see if you can get information from that point.
Right. Okay.
And if you're not satisfied, you may have to seek your own individual attorney to get a better interpretation.
Yes, will do. Okay. I know, you have to look at all the review.
Thank you, Lisa.
Thank you.
Sorry, may I ask the second question now?
Oh, that's right, you have to too.
Yeah, so I'm probably going to have to come back to you on that one. So the second one, we have a new management company over the last few months, and the manner in which they are now reviewing potential buyers or renters or guests or residents. They're using a company called tenantevaluation.com. And so the potential buyer or tenant, whomever, goes on there and starts filling out the application. Midway through the application, they have to pay a fee. It's not disclosed up front. And we asked, so recently, someone came back and said, well, okay, my mother owns this unit. She's not computer literate. Can I get a hard copy of it to review beforehand? And she asked, okay, we'd like to know how much the fee would be. And the management company has not disclosed that. So there's nothing in our docs that say a specific fee can be charged or if they can even charge a background fee. But normally speaking, in the past you always knew, okay, a rental was going to be $200 a fee, sale was maybe $250 plus the stockel fee, and all that. So is there anything that allows, that would, you could encourage the management company to disclose those fees? And the other thing is none of that fee is registering in the monthly income for the community, whereas in the past, $100 of those fees was kind of a small, went to as a source of income to the community. So whatever the fee is, the management company is basically keeping the fee. but can we compel them to disclose exactly what the fees are up front?
That's going to be up to the board, but they're not allowed to charge a fee for an application unless your documents authorize that fee. They can charge an estoppel fee at the time of the sale is going to be transferred. They are allowed by statute to charge a estoppel fee based upon certain criteria as to how much it would be, depending on where it stands in collections and whether it's a rush request. But for filling out an application for a background check, they are absolutely not allowed to charge for that unless your governing documents give express authority to do so. And in condominiums, there's a limit of $150 per application, husband and wife being one. But HOAs does not have a similar limitation as to a dollar amount in the statute, but it still needs to be identified in your documents. So if your documents don't have it, then they're not doing it correctly. But it's going to take notification from an attorney to get them to take that seriously.
Okay, great. Thank you very much.
Thank you, Lisa.
I appreciate it. Okay, bye-bye.
Let's go to our next caller. God, they're all over the place today. Boy, I'm going to have a tough time with this one. Is it Lashia in Jupiter?
Leisha.
Oh, Leisha. Okay.
Like Lisa,
Thank you.
Phonetically correct. It's Leisha.
Okay, Leisha.
Yes. And I live in a Bergen Vasta, 0 lot line, single family home in Jupiter, Florida that was originally built with shingle roofs. And a few years ago, we all took a survey as to changing the colors of the houses. Everybody got along okay. We picked palettes. We can do that now. A year or so ago, we all agreed to allow metal roofs. Yesterday, we get an email from the ACC committee, and they have decided we can no longer have shingle roofs. We can only have metal roofs. This was not on a board meeting. This was not in anybody's snail mail mailbox on this HOA. This was a decision made by an ACC committee. And guess what? I have an asphalt shingle roof that the ACC committee is supposed to be approving on August the 17th, at the same day that they tell me I can't have an asphalt shingle roof. What's the legality here?
Well, unfortunately, Alicia, you have the same problem as many of our callers in that your documents are what's going to control what your rights and obligations are on this point. The documents would have to empower the Architectural Control Committee to make those determinations and establish criteria of the nature you've described, which is unusual. It's usually not something that an Architectural Control Committee has that type of power. That usually, especially since you say you've had membership votes in the past on this type of issue, that might have been informal. It may not have been obligated by the documents, but the board at the time thought that it would be politically right to do that. So your documents really need to be reviewed as to these issues to see what limitations are on them and you. So you're going to need your own attorney, unfortunately, to address that, particularly if you're anticipating a disapproval of what you've got pending.
Correct. Okay, I understand, and
Now the other point,
go ahead, sir.
One other point for you to bear in mind is if your application was already in before the change was made, assuming they have the power to make the change, they would have to evaluate your application based on the criteria before the change. not after. They can't make it retroactive that way.
And in these times of the 15-year-old roofs, the citizens, the insurance, the costs involved, to change something so monumental without it even coming at a board meeting. It was never on an agenda of a board meeting. And I understand, and I'm ranting now.
It does sound wrong.
On a board meeting. Okay. Okay. Thank you so much. It sounded very wrong to us, sir.
Thanks, Leisha.
All right. Good luck.
Take care. Bye-bye.
Let's go to Dottie in Miramar. Hi, Dottie.
Hi, Dottie. Good afternoon. I have two quick questions. Am I allowed to call the name of my area or no? Is it
I
permitted?
would.
Okay.
You don't need to identify it.
Okay, we had an election. Our board has always operated with 5 people. And a couple of years ago, when I was the president, we voted to increase the board to 7, just in case that we are overwhelmed with fixing the community. The increase of the 2 board members has never been used. So we had an election and 2 people were voted off the board. The minute they were voted off the board, they decided they wanted to come back on the board. So they used the rule that we had in the bylaws that the board can be increased by 2. We have no problem in increasing the boards of the 2 members. Now, the 2 members that were taken off, the community voted them off because, whatever reason, they just didn't want them. But they decided they wanted to come back on the vote, on the board. So the president called a meeting. I wouldn't say it's a special meeting. He just sent out an email that he wanted these 2 people to be back. So the other 3 members voted for them to come back on. Now my question is, if the community votes you off for whatever particular reason, and they want to come back on the board, who votes for them? Is it the community, 2/3 of the community, or the board member voted for them to come back on? And in that same line, if that person has a criminal record, a hard criminal record, are they allowed to be back on the board?
All right. Second question first. If someone is a convicted felon and have not had their rights restored for 5 years, they do not qualify to serve on the board and may not serve on the board. Automatic. With respect to the first question, from the way you've described it, it's within what the bylaws contemplate. If the board is empowered to increase the size of the board from 5 to 7, and a majority of those 5 vote to appoint these 2 individuals, even though the membership did not vote for them to be on the board, then that's within what the law allows. There's nothing legally wrong with that. It may be politically wrong, but it's legally correct. Now, when you say the owners voted them off, they really didn't vote them off. They just didn't vote them on. So it isn't necessarily, if it was a recall that was affirmatively to remove them, then the board wouldn't be able to immediately appoint them back on. That's a different set of circumstances.
Just another question.
Okay, we've only got about 30 seconds, Dottie.
Yeah, and it's a 1. It's homeowners. Can the homeowners vote them off?
Yes, by recall. Go to the Department of Business and Professional Regulation website, look up condominiums and homeowner association. There's a form for recall petition. You just need a majority of the owners to sign it and then deliver it to the association by certified mail or by a process server, and then those members would be removed from the board.
Thank you. So if you have a criminal record for drugs or fraud, you're not allowed to serve on the board.
If you have a convicted felony, it has to be a felony and it has to be a conviction.
Yes?
And then the other criteria is that your civil rights were not restored within 5 years or longer than 5 years.
Yes.
Okay. Thank you, Dottie.
Thank you very much.
Thank you.
Okay, bye-bye.
Wow, what a big night tonight. Give everybody your phone number and your website address.
You can call us at 800-974-0680. You can go to kbrlegal.com. There's a contact box you can fill out, or you can write to us at info@kbrlegal.com. Always fun to talk to all of you, and it was nice to spend our August Thursday. We'll be back on the 1st of September, right?
That's right. Well, you'll be at the last August, too. The last Thursday. Anyway,
me, but
thank you so much.
here.
We'll be with you next week with our restaurant show. Everybody have a good week. We'll see you soon.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed on the preceding sponsored program were strictly those of its host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.